Hi everyone, welcome to my YouTube channel Learn Commerce with Namita. I am Namita Mane. In today's session, let us discuss about Limited Liability Partnership Act 2008. So let's start. Introduction. The Ministry of Law and Justice on 9th January 2007 notified the Limited Liability Partnership Act 2008. So Indian Partnership Act is different from Limited Liability Partnership. Okay. So these are two different acts. The Parliament passed the Limited Liability Partnership Bill on 12th December 2008 and the President of India has signed the bill on 7th January 2009, and after that it is called as Limited Liability Partnership Act 2008. So how does the Limited Liability Partnership Act 2008 came into form? It came into form in the year 2008, okay, and it is different from Indian Partnership Act 1932. So Limited Liability Partnership, that is also called in short LLP, is different from Indian Partnership Act 1932. So this act, means Limited Liability Partnership Act, has been enacted to make the provision for the formation and regulation of limited liability partnership and for the matters connected with or incident thereto. So there is first of all there is partnership firm. So if the partners comes together to form basically a company or a business, so all the laws and rules and regulations related to the partnership firm is governed by Indian Partnership Act 1932, and limited liability partnership is different from that partnership act. Limited liability partnership is a combination of two types. First is partnership and second is private companies. So it is a hybrid of private companies and partnership firm, and then it is called as limited liability partnership. Now in Limited Liability Partnership Act LLP 2008, the act has 81 sections and 4 schedules. First schedule deals with the mutual rights and duties of partners. So in limited liability partnership, there are partners. Okay, to start the limited liability partnership company, there we require partners. So first schedules deals with mutual rights and duties of partners as well as limited liability partnership, and in partners where in absence of formal agreement with respect to them. In Indian Partnership Act 1932, the liabilities of partners were unlimited. In limited liability partnership, the partner's liability is limited. Okay, this is the one of the important feature of this act. Schedule 2 deals with conversion of a firm into limited liability partnership. Now suppose a partnership firm, if they want to convert their partnership firm into LLP, they can convert according to the second schedule. All the procedure of conversion is given in second schedule. The third schedule deals with the conversion of a private company into LLP. Okay, so schedule 3 of the act deals with conversion of a private company into LLP. Okay, if any private company is there, if they want to convert their company into limited liability partnership, they can convert, and all the provision, all the procedure or rules and regulation is given in third schedule of the act. The fourth schedule deals with conversion of unlisted public company into LLP. Okay, so in the act, in 4 schedule, second schedule, third schedule and fourth schedule deals with the conversion of the firm, conversion of private company, conversion of unlisted public company into LLP. Okay, so this so total in LLP Act 2008 there are 81 section and 4 schedules. Next, we'll try to understand the meaning and concept of limited liability partnership, that is LLP. So LLP is called as a hydrate, okay, between a company it can be also called as private limited company and partnership firm. Now it is basically the mixture of a corporate structure. Corporate structure means a company, and the mixture of private partnership firm structure. Now the features of Company Act, few important features of Company Act and some important features of Partnership Act, they have took and they have formed the Limited Liability Partnership Act. Okay, so it is a mixture of partnership firm. Okay, it is a mixture means LLP, Limited Liability Partnership, is the hybrid or mixture of partnership firm plus private limited companies is equals to limited liability partnership. Okay, so some important features of partnership, some important features of Company Act, they have took and they have formed limited liability partnership. If suppose a person wants to start a company, so that person has a choice whether he can start a partnership firm, where he can also start a private company, or he can also start a limited liability partnership. So it depends on the nature of the business what that person wants to start. Okay, so this new concept has come in 2008. Okay, so government has started this limited liability partnership. So basically, in short, meaning or concept of limited liability partnership is what? It is the mixture or hybrid of partnership firm plus private limited company. Okay, so it means, okay, it means a partnership formed. Limited liability partnership is a partnership and it is formed and registered under LLP Act 2008 in the section 2 subsection N. LLP is a new form of legal business entity with limited liability. This is the important feature, okay, in LLP Act. In Indian Partnership Act 1932, the partners in the partnership firm, their liability is unlimited, okay. But in this act, in this type of partnership, the liability is what? Limited. Okay, so LLP is a new form of legal business entity with limited liability. Next is LLP is an alternative corporate business vehicle, and this corporate business vehicle is that not only gives the benefit of limited liabilities at the low compliance cost, but allows its partner, okay, it allows its partner the flexibility of organizing their internal structure as a traditional partnership. Okay, so basically LLP is an alternative option for cooperative business business vehicle, and which allows, okay, which allows not only the benefit, it also gives the limited liability facility at a low compliance cost, and it also allows the flexibility to the partners of organizing the internal structure of the business. The liabilities of the partners will be limited. Okay, this is very important. The liabilities of partners in limited liability partnership will be limited. Okay, and LLP itself, okay, LLP itself is a separate legal entity. Okay, and that's why all the liabilities, or that's why it will be liable for the full extent of its assets. So this is the concept or meaning of LLP. Next we'll move to the features of limited liability partnership. So first feature is LLP is a body corporate. Okay, so section 2 subsection 1 D of the act provides that LLP is a body corporate and which formed and incorporated under this act. It is legal and it has a separate legal entity. Okay, separate legal entity that from that of its partners. Okay, so business of limited liability partnership is a separate legal entity from its partner. Okay, so the next feature of LLP is perpetual sections. Okay, a perpetual section means never ending. So limited liability partnership will never end, even though if one of the partner in the business is dead or is insane or retired, still the limited liability partnership will be continued. Okay, so the limited liability partnership can continue its existence irrespective of change in the partners. Okay, if there is change in the partners, still the LLP business will continue. Okay, so death, insanity means insane, retirement of partner or insolvency of partner has no impact on the existence of LLP. Okay, next feature is separate legal entity. The LLP is separate legal entity and is liable to the full extent of assets, but the liabilities of partner is limited to the agreed contribution to the LLP. So the liabilities of LLP, the partners will be limited and it is separate. LLP is a separate legal entity. Next is non-applicability of Indian Partnership Act 1932. So the provisions of Indian Partnership Act, the provision of Indian Partnership Act 1932 shall not apply to LLP. Okay, so LLP, the act of limited liability partnership is different, the provisions are different, and the Indian Partnership Act is different, the provisions are also different. Suppose a person wants to start a business of a limited liability partnership, then he will be governed under LLP Act. Okay, so the provisions of Indian Partnership Act will not be applied to limited liability partnership. Next, mutual agency. This is one of the important feature of LLP. So no partner is liable on account of independent or unauthorized action of other partner. Now in Indian Partnership Act 1932, if any one partner, suppose there are three partners as per Indian Partnership Act 1932, one of the partner does some fraud, okay, then other partners and the business of partnership will be affected. But in limited liability partnership, if the partners, okay, if in limited liability partnership there are four partners and out of this four partner, one partner does some fraud, okay, does some misconduct of business or conduct some wrongful business decision, then other three partners will not be affected. Okay, they will have some protections. Okay, so other three partners will not be suffered in LLP, but whereas in Partnership Act, okay, 1932, all the three partners will be affected because of one partner's mistake. Okay, this is the difference of Indian Partnership Act and difference between LLP. So mutual agency is what? No partner is liable on account of independent or unauthorized action of other partner. Thus, individual partners are shaded from joint liability created by another partner's wrongful business decision or misconduct. Okay, so even if in the LLP, okay, four partners will if suppose in LLP there are four partners, and out of that four partner, one partner does some misconduct or wrongful decision or some fraud, other three partners will not be liable for his action. Okay, they will not suffer. But in Partnership Act 1932, all the partners will be liable for his misconduct. Okay. Next is LLP agreement. So mutual rights and duties of partners within the LLP are governed by an agreement between the partners. So all the rights and duties of the partners in LLP will be governed in a agreement. Okay. Next feature is artificial legal person. Now LLP is an artificial legal person because it is created by a legal process. If you want to start a business under LLP, so you are going to start with all the required legal process. Next important feature is limited liability. The liabilities of partners will be limited to the agreed contribution in the LLP. Next feature is management of business. What type of business will be there? So the partners in LLP are entitled to manage the business of limited liability partnership, but only the designated partners are responsible for legal compliance. Now what is this designated partners and partner? Now designated partner is new concept in limited liability partnership. That's why it is different from Partnership Act 1932. Now in Partnership Act 1932, there are general partners. Okay, there are sleeping partner, dominant partner, nominal partner, and so on. But in limited liability partnership, there is a new partner called as designated partners. Now designated partners are similar to the directors of private company. Okay, so they are similar to the directors of private company. Okay, so management of business will be the partners. Okay, partners in liability in LLP are entitled to manage the business of LLP, but only designated partners are responsible for legal compliance. Okay, whatever the formalities of legality is there, they will be responsible for that. Now minimum and maximum numbers of partners. Now every limited liability partners shall have at least two partners, and shall also have at least two individuals as designated partners. And out of this one, okay, out of this two designated partner, one partner should be resident in India. Okay, should be resident in India, and there is no maximum limit on partners in limited liability partnership. So the minimum and maximum numbers of partners, the minimum number is what? Two partners should require, and there is no maximum limit of partners in LLP. But designated partners should be only two, and out of that two, one partner should be the resident in India. Business for profit only. Okay, now you are starting with LLP, so the main motive of that business will be profit only. So essential requirement for forming LLP is carrying on a lawful business. The business should be lawful with a view to earn profit. Now there is one more important feature of LLP, that conversion of LLP into LLP. So a firm, either it is a partnership firm, private company, or unlisted public company, can allow to be converted into LLP. Okay, in accordance with the provision of LLP Act 2008. Okay, as per the provisions of LLP Act, a partnership firm, a private company, or unlisted public company, they can convert their business into limited liability partnership. Next, according to the section 5 of Limited Liability Partnership Act 2008, what there is a definition of partners. Now what are partners in LLP? So partners, any individual, okay, any individual or body corporate may be a partner in a LLP. But however, there are some individuals who are not capable of being partners of LLP. They are as follows. So an individual shall not be capable, okay, some individuals are not allowed to become a partner of a LLP if, okay, if an individual has been found to be an unsound mind, okay, unsound mind means insane, idiot, who does not have capacity to think rational, okay, he has lost his memory, whatever the case may be, okay. So unsound person cannot be a partner in LLP. Or he is an undischarged insolvent. Next, he has applied to the judicate as an insolvent and his application is pending, okay. So unsound person or person with a criminal record or the person or with an insolvent, okay, that person cannot be a partner of LLP, okay. So individual or body corporate can be a partner in a LLP, but this persons like unsound person, insolvent person cannot be the partner of LLP. Now section 7 defines designated partners. Now as I said earlier that designated partner is some new term in limited liability partnership. This term is not used in Indian Partnership Act 1932. So designated partners are similar to the directors, okay, they are similar to the directors of private company. So every limited liability partnership LLP shall have at least 2 designated partners, okay. So how many designated partners are required for LLP? Only 2, okay, who are individual, and out of this 2 partner at least one of them shall be a resident in India, okay. Now what do you mean by resident in India? So resident in India, for the purpose of this section, okay, for the purpose of section 7, the term resident in India means a person who has stayed in India for a period of not less than 182 days during the immediately preceding 1 year, okay. So designated partner will be any individual person, but in LLP only two designated partners are required, and out of that 2, one partner should be resident in India, okay. So resident in India means any person who has stayed in India for the period of not less than 182 days, okay. So that person can be the designated partner for LLP. So if in LLP all partners are bodies corporate, or in which one or more partners are individual and body corporates, at least 2 individuals are who are partners of such LLP or nominee, such body corporate shall act as an designated partners, okay. So this is the concept of designated partners. So now I hope you have understood the Limited Liability Partnership Act 2008. I hope you have understood the features of LLP, what is partner and designated partners. Thank you. In next session, we will see incorporation of LLP. Thank you very much. Please subscribe my YouTube channel. If you have liked my video, do like and share the video. And do not forget to press the bell icon to get the latest notification.